Estate planning has two components. The first component is to make sure that you have a plan in place that would allow people to take care of you while you're still alive if something happens to you and you become incapacitated. So that's the first component. And then the second component is to make sure that the people you want to inherit your property when you die inherit that property in a smooth and orderly manner. For example, while you're still living, let's say that you suffer a serious medical injury like a stroke and you can't make decisions or care for yourself anymore. If you don't have a healthcare power of attorney in place, there's nobody that is authorized to do so. So in that situation, you'd have to have a guardian appointed by a court to take care of you and make those medical decisions. And a guardianship is an expensive proceeding. It's also stressful. It involves lawyers, it involves doctors. So you can avoid that by having a proper plan in place and making sure that not only the documents exist to avoid the guardianship, but also making sure that you've got the proper person in place to make those decisions on your behalf. If you don't have an estate plan in place, then the state determines who inherits your property. So that's called the law of intestate succession. So the state would determine who your heirs are. With an estate plan, you can choose who you want to inherit your property. And then there also needs to be a person to make sure that plan gets carried out. In Arizona, if a will goes through probate, we call that person a personal representative. In a trust, we call that your successor trustee. So the primary difference between a will and a trust is if you create a trust and you fund that trust properly, then your assets and your estate pass outside of probate. So whoever is designated as successor trustee in your trust agreement would have a minor bit of documentation prepared, and then they can begin to administer and distribute the assets of your trust to your beneficiaries. Now, with a will, that's a legal proceeding called probate. A will has to go through probate, where a court will make a determination about the validity of the will. If the court determines the will is valid, a personal representative would be appointed to administer your estate and then distribute the property to the beneficiaries that you've designated in your will. The significant difference between a will and a trust is a probate is a public proceeding, so people don't want their affairs made public. They can avoid that by creating a trust. And then a second difference is that because probate's a legal proceeding, it can take much more time and expense to administer the estate than if a trust is created. One of the reasons why we like to recommend people create a trust is the protection you can give to your beneficiaries. So with the trust, you can determine how your beneficiaries will receive the inheritance that you leave to them. What we advise our clients to do is leave that inheritance to each beneficiary in a separate trust. The beneficiary receives is that inheritance receives lifetime asset protection from any potential creditor claim that may arise during their life. The primary concern that a lot of clients have is what if their beneficiary, their child or whoever that may be, gets divorced from a spouse. They don't want that ex-spouse to receive their inheritance. Additionally, there could be a number of other claims that the inheritance would be protected from, like bankruptcy, medical debt, any type of personal lawsuit. By leaving your inheritance to a beneficiary in a trust, the beneficiary is protected from any one of those claims. Creating an estate plan, you're leaving a legacy to your loved ones, your beneficiaries, and who you want to inherit your property. People work hard during their lifetime to accumulate the wealth that they've earned, and you don't want it squandered through fights between your kids or other beneficiaries. So to properly protect that legacy that you've created, you do that through comprehensive estate planning. So that could be through dynasty trusts that pass through generations of subsequent family members. It could be a number of components. Another component within that subset is maybe you want to leave money to charity. And you can do so through any number of different trusts that can potentially not only provide a benefit to the public by funding a charity, but also potentially save you money in taxes and maybe even your family members or beneficiaries in taxes. So if you ever have any questions about estate planning, feel free to reach out directly to me. And I'm happy to answer any questions you have. We have a free initial consultation, and I look forward to speaking with you and answering any questions regarding estate planning.